Okay, this is the legal prophet Legum Bakery's candidate, and we are laboring to see that we simplify the law, we make it easy. If you can manage to demystify, help the others that cannot. So tonight we are going to look at jurisprudence, that is the introduction to jurisprudence in Uganda, that is YAFO, semester 1. We first of all have to begin with what is jurisprudence. With what jurisprudence, we are going to say, or we are going to find that there is no conclusive definition of jurisprudence. It is not there. However, jurisprudence comes from two Latin words, that is juris and prudentia. Juris means law, and then prudentia means knowledge. So when you combine the two, you get what we call knowledge of the law. So basically, if you have, or you are well groomed in jurisprudence, you have what we call knowledge of the law. So when you go to jurisprudence, we are going to see that it comes from, or we study it within education. So relate it with education. And with education, you'll also find that it comes from a French word known as, French or Latin word known as educare or educere. All those while combined, you get what we call bringing out. So education is basically to bring out someone. So you'll see that different philosophers will come in to explain the importance of education, such as Socrates, Plato, Aristotle, but they all come up with the same by saying that it is important because it grooms someone, it imparts knowledge, among others. So because of time, we have to know what law is. We have said that there is no conclusive definition of jurisprudence, but different scholars attempted to define what jurisprudence is, such as Salmond, among others. So you should find out the different definitions of jurisprudence by the different scholars. So tonight we are going to find out what is law. Again, when I talk of what is law, there is no conclusive definition of what law is, but the different scholars have attempted to term or to come and define what law is. So while defining what law is, we are going to concentrate on the schools of thought. So a person should note that there exists the following school of thought. One, historical school of thought. So the historical school of thought has got very many people, such as Montesquieu. It has got people like von Savigny. It has got people like Sir Henry Miney. However, you cannot come up with everyone's definition. Just say the historical school of thought defines law as that develops as a result of historical events. So you'll see that the historical school of thought believes that you cannot know what law is unless you've tried to trace its historical backgrounds. So the second is what we call the sociological school of thought. So the sociological school of thought, again, it has got very many people such as Rousseau. It has got very many people such as Jaring, but we can come up with their definition, and we say that they define law as that one that relates to the needs of the society. That you cannot know the law unless you know its needs. Why was it made? Unless you know the problems that are being or that are facing the society. So that's the sociological. Then we go to the natural. Natural is wide. It is wide because we see it in 4 stages. That is the ancient. That is the era of the Greeks. We see it in the medieval. That is the Roman era. Or you can find it. There is what we call the Renaissance. That is the era of the social contract. And the modern natural law. That's the era that comprises of scholars such as Stuart Mills, among others. So natural law, basically for them, they believe law to be that originates or that conforms to nature, morality, justice, respect of religion, among others. So for natural law, it is wide. So there is no, you cannot only concentrate here, because I've told you that natural law has got different stages: ancient, the modern, the medieval, and the Renaissance. They all define natural law in a different way, but just know it is this law that conforms to nature, justice, morality, among others, and religion. Then when we go to the positivists, these are the people who believe in what law is and what law is and not what law should be. So the positivists majorly, it comprises of scholars such as Bentham, it comprises of scholars such as Austin, but we majorly concentrate on the definition that was laid by John Austin, who said that positive, who says that law is a command from a political sovereign that is backed up by sanction for its breach. So basically, to the positivists, they believe that law is that is a political command that is backed up by sanctions in case it is breached. So we concentrate on his definition. Okay, let's go to what we call the pure theory. How did pure theory define what law is? So the pure theory, this is what the theory that was laid by a scholar known as Hans Kelsen. So Hans Kelsen had this to say that law is a hierarchy of norms that base their validity from the grand norm. So for him, he brings in the aspect of norms and hierarchy. So he shows that there is a grand norm, which is the Supreme Court, which is the Constitution. There are norms, which are the Acts of Parliament, and sub-norms, which are the SIs, or the statutory interpretations, the statutory instruments. So to say that this is a valid law, it must be conforming with what the grand norm says. So that is another discussion, but just know the pure theory. Then let's go to the Marxist school of thought. The Marxist school of thought that was introduced by Karl Marx and Friedrich Engels, among others. For them, they believe that law is that material thing. They believe not in ideology. What do you think? No, law is what you see. Law is what you touch. Law is what you feel. So to them, they believe in the materialistic aspect of what the law is. So basically, that is some of the definitions of law according to the various schools of thought. Thank you.